Hey viewers, you're watching The Savera and I'm Vidhi Joshi. The Bombay High Court on Wednesday, that is today, dismissed a public interest litigation filed against the Italian fashion house Prada for its alleged unauthorized use of the famous Kolhapuri Chappals. The petition filed by 6 Pune-based advocates accused Prada of showcasing sandals in their summer collection that were deceptively similar to the traditional Kolhapuri Chappals, which are protected under the Geographical Indications of Goods Registration and Protection Act as a cultural symbol of Maharashtra. These Prada sandals, described as touring sandals, were priced at Rs 1 lakh per pair and had been featuring at Milan Fashion Week. The bench, comprising Chief Justice Alok Aradhe and Justice Sandeep Marne, raised serious questions regarding the locus standi or statutory right of the petitioners to file the suit. The court noted that the advocates were neither the aggrieved parties nor the registered proprietors or owners of the Kolhapuri Chappal. You are not the owner of this Kolhapuri Chappal. What is your locus and what is the public interest? Any person aggrieved can file a suit. What is the public interest in this? The court questioned. It emphasized that infringement matters must be pursued by the actual aggrieved parties, such as the registered proprietors of the geographical indication tag, rather than through a public interest litigation. Senior counsel Ravi Kadam, representing Prada, argued that a GI tag is akin to a trademark and opposed the PIL on those grounds. The court clarified that injunctions and infringement actions cannot be granted through a PIL and that such matters require detailed examination of evidence in suits filed by those directly affected. The bench dismissed the petition but noted that a detailed order would follow. The PIL had demanded that Prada be restrained from commercializing and using its touring sandals without authorization and sought a public apology and acknowledgement from the luxury brand for drawing inspiration from the Kolhapuri Chappals. It also sought compensation for the artisans community, alleging reputational and economic damages caused by Prada's alleged copying of the traditional design. The petitioners further requested an inquiry into the violation of the rights of the GI registered proprietors and the artisans, along with an interim order for damages and a temporary injunction against Prada from marketing or exporting the sandals. The petition claimed that although Prada had privately accepted its collection was inspired by Indian artisans, it had not issued any formal apology or compensation, and that the acknowledgement was merely a superficial attempt to deflect criticism. The advocates also urged the Maharashtra government authorities named as respondents to protect the rights of the Kolhapuri artisans and ensure appropriate compensation for the community. However, the High Court's dismissal highlighted that only the registered proprietors of the GI tag have the right to pursue legal action regarding such intellectual property issues, and public interest litigations are not the proper route to address alleged infringement claims. The court left open the possibility for the aggrieved parties to file suits individually and explore their legal remedies accordingly. That's all for now. Stay tuned to The Savera for more updates. Do like, comment and subscribe to the channel.